We're ready to start the next module / section.
Thanks.
And that would be Dr. Kleiman.
Great. So we spent a lot of time this morning talking about offense gravity score. We're going to pivot a little bit and now talk about the prior record score. And I just want to start by saying that at the last commission meeting, Mark spent a lot of time talking about the history of the guidelines and the development and thinking about the 8th edition guidelines and all the work of the strategic planning work group, the subcommittee work that was done, especially the academic review panel. A primary focus of that panel was on this prior record score. And we really spoke about 3 different areas we thought we could improve the prior record score. One was to simplify, the other was to automate, and then the third was to reduce the impact of criminal history. So I'm going to spend a little time, hopefully not too much time, talking about the current prior record score and then our efforts to redesign that from a points-based system to a categorical-based system. And it will allow for a little bit of comparison using some data that we have. We do have a little bit of data limitations, but to see what some of the impacts associated with this new prior record score are. So currently prior record score is based on the type and number of prior convictions and prior juvenile adjudications. There are 8 prior record score categories, 0, 1, 2, 3, 4, and 5, and then our repeat violent offender and our repeat felony offenders. And the prior record score shall be the sum of the points accrued based on the previous convictions or adjudication up to a maximum of 5 points. Important also to note, in order for offense to be considered in the prior record score, both the commission and conviction for the previous offense must occur before the commission of the current offense. Okay, so that's just some definitional components. Here's the prior record score. Before we were talking about the vertical axes. Now we're looking at the horizontal axes. Again, 0, 1, 2, 3, 4, and what we call RFEL and REVOC. This was already hinted at in the earlier sessions, but there's really 2 rationales for the inclusion of prior record score. One being risk in public safety, and the other being retribution or culpability. In some previous work that was done by folks at Carnegie Mellon and by Reese Hester and others, they looked at the recidivism rates based on data from 2004, 2005, and 2006, which is the database that was used to construct the risk assessment tool. That's unfortunately, the most contemporaneous information we have associated with recidivism. But utilizing that, and this is arrest within a 3-year period leading to a conviction is our definition of recidivism. You could see if risk that the current configuration of prior record score does not really accommodate or reflect risk in the sense that we would expect a stair step between categories. And we see here at categories 3, 4, and then the combined categories of RFEL and REVOC are all the same at 40%. So the current configuration, at least, of prior record score may not be a great proxy for risk, but I think it's probably considered in the vein of retribution and blameworthiness of adding additional penalties associated with repeat offending.
I'm sorry to jump in, but this has been on my mind for like 48 hours, so this might be the best place to jump in. The notion of specific and general deterrence, where does that fall in? I mean, these 2 rationales, and I remember working with Reese on this project, and when we talked about the rationales for inclusion of prior record, does deterrence play a role? Is that a potential rationale for inclusion of prior record? In other words, somebody seeing someone else with a long criminal history, spending longer periods of time incarcerated. I mean, is that a factor?
So when they talk about deterrence and whether it works or not, they talk about like 3 different factors, the timing and the severity. And I don't know how any of that would relate to a prior record score itself. I think, you might be right, like tangentially, there might be some kind of thing that someone gets a really long sentence because of a really long prior record score, but linking that to someone not committing a crime because of that is a big stretch, because the research basically says deterrence is just, it's just not that positive thing, not that effective a strategy. The examples of sort of positive general deterrence was like the DUI stuff. And that was when there was a lot of focus on it, a lot of change in policy. It was really advertised, and there were consistent policies. But like that doesn't reflect this, especially when there's not really a distinction. So I'm just trying to think of a time when, you could say, yeah, there's something there, but I'm not sure.
I'm just thinking of the individual who, is like a frequent flyer. I mean, they're always getting arrested. They're always getting in trouble. I don't think the community is surprised when that person is missing for 3 to 6 years because they were in state prison, because that individual had always been in trouble. And I just wondered whether that plays a role or not, and if it does, to what extent. So your opinion is that it doesn't.
I don't think that the person in the community would see themselves in that place. They'd say that guy's just different, or he's a waste, or they wouldn't connect the two. And that's one of the things on the deterrence research. They're always talking about these connections, like you're connecting it's sort of Skinner kind of stuff. The whole idea of connecting that kind of behavior to this kind of concept. And the less you have of that, the less effective the deterrence
is. Is some of this similar to what the commission, and this predates me, found in that mandatory study about really the lack of predictability? People didn't think that the mandatory was going to apply to them, so therefore it wasn't a deterrent for them. I mean, is it the same general concept?
That was exactly it.
Well, if that's the case, and one of the things we talked about this morning was the broad range that many of our boxes on the matrix have in terms of, and it really doesn't lend itself well to predictability or proportionality or consistency across the state, because literally so many of these boxes, you could either have probation, a state sentence, or a county sentence. And so I just wonder if this is all tied together. I mean, it's hard to effectuate deterrence if you don't have any real predictability about outcomes, and you can't really have predictability of outcomes when you have such broad ranges. I mean, are they all tied together in some respects?
I think you're onto something there, and I think that's why sort of simpler is better. If there's a theme that we've been talking about, it's like coming up with categories so that you can be really clear about what that category is and isn't, and what you're doing with that category. But when you have 8 prior record score categories and they really don't differentiate, and we put like apples and oranges together in a packet, it doesn't give anyone some kind of sense of like, that's what that means. But I think when you get to something and you say, like, I think actually RFL and REVOC is actually not a bad thing, because it's pretty clear what it is. It's just really narrow. It's a repeat offender, but you also have to have a current, violent offense. But at least that's categorical, and that's helpful. I think we get into this like math stuff, and I don't think it connects to deterrence.
Okay, thanks.
Excuse me, Matt, let me just kind of follow up on that. I think it is extremely important when we talk about prior record score, because oftentimes we forget that the prior record score includes juvenile delinquency. And, throughout the academic panel, it was often brought up that, the literature, even the Supreme Court in Montgomery and Miller, basically makes a distinction. And those of us who have been involved in juvenile delinquency in court have heard time and time again that, this is not a conviction, it's adjudication, it's in the best interest of the child. And oftentimes, maybe not a guilty plea, but an acceptance of delinquency is accepted and the program is established. And for some reason, maybe when the kid is 24, 25, he's arrested again. And wow, that delinquency is considered a conviction. And I think, well, it's fundamentally unfair because, I mean, we all know through the court decisions and the programs that it shouldn't be, because the kid, again, is sometimes accepts a placement or something like that because mom really doesn't have the time. She's there alone. And then again, when he's 24, it's another one is considered as a conviction. And then when he's 26, arrested again, 29, arrested again. And so repeatedly is laid upon him. But from the beginning, we said, look, we're not going to count this. The record's sealed. And so I think when we talk about this, we have to consider that, because it follows the individual, male or female, with a balance of their criminal career. So I'm just mentioning that to say that as we talk about this, if we could also, instead of me chiming in, saying, hey, what about the juvenile? If we could address that as well, I think that would be great.
Yeah, and I know Matt is going to talk about that. It was a key area of the academic review panel, and a really strong suggestion about really reducing and eliminating consideration. So I know Matt will talk about it. Let me just mention, though, one reason why there's consideration of juvenile adjudications outside of it being in the statute, that we have to consider it. But if you think about juvenile offenders, and you look at those two factors or reasons or rationales for a prior record score, juvenile offenders work in two different directions on that. On risk, they're at really high risk of reoffending. An 18-year-old is, especially one who has been in the juvenile system, is at a really high risk of reoffending relative to the general population. The young male offenders is sort of, that's where the action is in terms of new offenses.
But when you say 18,
yeah,
I mean, he's in the adult system now.
Right, but if he started offending at 14 or 15, has a record that made it into the prior record score as a juvenile adjudication, and he's continuing to offend, he's in court today, 18, 19, because of a new offense, and he has that prior, it plays into the whole the research about risk for younger offenders that have juvenile adjudications and then reoffend in the criminal justice system. But Judge, your point is exactly true in the opposite direction, which is on retribution. We're punishing someone where the retribution should actually be low. They're early in their career, or they're an opportunity to intervene and do something different. And if we penalize them with a heavy prior record score because of juvenile adjudications, it can be counterproductive. So I think, the committee talked about it a lot, but I just think one of the reasons it's included is the risk side and less the retribution side.
I guess the concern that I have is that he's been promised that we won't count this, but then we count it time and time again.
Yeah, so in a few minutes, when we present the new model of prior record score, we'll have what our recommendations for how to treat juvenile adjudications differently than the current model.
Yes.
All right, well, one thing to note, and again, this is just really brief on the current prior record score, that almost half of the folks who are sentenced, this is from 2018, have a prior record score of 0. Now, it's worth pointing out that this is, as Mark said earlier, we don't have a true 0 in the current model. This could be one misdemeanor offense that's kind of counted as a half point that doesn't get you to the 1 point. So it's not a true 0. And we'll see in the new model, the introduction of a true 0, as well as a a lower prior record score category. All right. And my apologies for jumping back to OGS real quick, but I wanted to give a distribution of blacks versus whites as it relates to OGS and PRS on our current matrix. So this shows the percentages of blacks who are sentenced by OGS level. So the population is 27% are black. And as we see from OGS 1 to 5, it kind of mirrors the proportion of offenders in each of those who are black, the general population. But as we move up between 6 and 11, we see that disproportionately there are a lot of blacks at those higher OGS levels. So the instantaneous offense that they're being convicted of is more severe, the higher proportion of blacks at those higher OGS categories than there are whites. This diagram is now looking at the PRS categories and looking at prior record score also by race. And it's the same 27%. And we see that as you get above, move towards 4 and 5 and RFEL, and Revoc has very few cases. So that spike is not the greatest. I should have combined the categories, my apologies. But we get close to 45, almost 50% for RFEL relative to the general population. So there's a disproportionate number of blacks who have higher PRS. So when we take a look at this holistically, what we see here on the left is looking at a comparison of where proportions of blacks are higher by OGS for each of the PRS categories. And then the one on the right is showing the proportion at each PRS level for each OGS category. So we can see on the left that there's a higher proportion of blacks at higher OGS levels, almost across all PRS scores. And then from above 3 on the PRS scale, a higher proportion of black at almost every OGS category. So this is something from a racial perspective of how to reduce this disparity that the academic review panel thought a lot about. We worked on significantly, and I will share what our results are, at least related to the new matrix later. But some of to kind of prime that is to think of what control does the Sentencing Commission have when developing the prior record score. So these are prior convictions. They're, in this model, blacks are being convicted for more serious offenses, in this case, which have more points. They have a higher risk and they recidivate at higher rates than whites. So there's police practices, prosecutorial practices, judicial practices before the Sentencing Commission even has a say in how we construct prior record scores. So we'll return to that at the end when we showcase what the new model looks like or the new prior record score relative to race. Okay, not spending a ton of time on the current matrix, but again, there are certain offenses that are scored differently. 4 points are our crimes of violence. 3 points are things like aggravated assault, attempting serious bodily injury. So these are the scoring for offenses, and then those scores are summed up to give you your prior record score based on repeat offenses, all the way down to misdemeanors, misdemeanor 1 offenses involving weapons getting 1 point.
This is super fast. We don't keep track now of arrests just because that's sort of for our involvement, but it would certainly be, I think we talked about that, a really good measure, because I'm curious across the board, but also by race, like what are they getting charged with more serious things at the beginning? Are they getting less consideration in plea negotiations? And I think arrests would be, and I don't know how you collect that data. But wouldn't that be another component that would help us kind of figure that out? Because I understand that occurs before it gets to our step, but if we understand that, we could make some changes based on it.
Yeah, and in some of the research we've done, we do what's called attrition studies, where you start with, who's charged and move through the system and see how the case plays out and what cases are dropped and what cases go through and so forth. And we did that when we were looking at mandatories and just, how often was the mandatory applied and so forth. And you do see that there's racial differences in that approach. The biggest takeaway was just, I I think with like deployment of law enforcement that there's, and it's more location than race necessarily, but where are you deploying law enforcement, where the crimes are, something like that. They talk often about, that drug offenses are sort of different because police are sort of actively engaged and they can be deployed in certain areas, whereas for like violent offenses, you're responding to an incident, you have a victim. And so I think those things like play out differently. But we can look at that. When we did the study of risk assessment, what we did find was that by moving from arrest to conviction, we reduced racial disparity. Didn't eliminate it, but it reduced it. And the speculation was that it was because there were just more arrests that didn't lead to convictions in a more disparate way.
All right, so just going back one, and I'll highlight this again later. This is, again, convictions or adjudications are getting scored for those offenses. And then for all other misdemeanors, there's an amalgamation of how you get specific points. 1 point for 2 or 3 misdemeanors, 2 points for 4 or 6, 3 points for 7 or more. So you can begin to start seeing that this is a little bit of a complicated scoring system, that we just think 3 points is 3 points, but 3 points can be a lot of things. I'll come back to juvenile later. So for example, in this example for 3 points, you could get 7 prior misdemeanors and get 3 points, or convicted of prior aggravated assault, attempting serious bodily injury. And should these 2 offenders receive the same prior record score? So we think of it as 1, 2, 3, 4, very linear, but it's actually a combination of lots of elements that are complicated that remove the linearity. So we might not be surprised at earlier risk illustration that the categories don't differentiate, because 3 or 4 points could be accumulated in a lot of different fashions, from one offense to multiple offenses. And so just one more example of, you get 4 points from 4 1-point theft convictions, 4 1-point stalking convictions, or 1 4-point aggravated assault causing serious bodily injury. Are we treating them the same? Are they the same? And again, in terms of recidivism, are they the same? But we're grouping them into the same, in this case, numerical point-based categories. So one of the other things was to reduce that we had as a goal was to reduce the impact of prior record scores. So I'm just going to take a quick look at OGS 5. So at prior record score 0, the recommendation here is between restorative sanctions up to 9 months for the standard range. As you move across to RFEL, we see that you go now from restorative sanctions all the way up to state prison. So it has a big impact on the disposition type that one might receive, at least based upon the recommendation of the standard range. So there's a lot of movement there from PRS 0 to our RFEL category. Another way to think about it is to think about the impact on the recommended duration. So the bold numbers there are the lower limits of the standard range for each of those OGS categories. So for example, at PRS 0, OGS 13, the lower limit of the standard range is 60 months. And then we're looking at when PRS is RFEL. So if we look at OGS 12, we could see that PRS 0, OGS 12, it's 48 months is the lower limit of the standard range. At RFEL, it's 96 months. So the ratio is you double the duration. And the difference is 4 years. When we come down to OGS 6, now the lower limit's 3. At PRS 0 at RFEL, it's 27. So that duration is 9 times solely based, the recommended duration of the lower limit of standard range, 9 times based solely on the impact of prior records. So this mini analysis was the driver of some of our conversations with the academic review panel, who talked about reducing that impact as you moved across the prior records. One of the other just quick things is currently, because of that complicated nature of the way that it's scored, these are scored by hand, prior record score on this guideline sentencing form. And you could see there's a lot of boxes to check or to look at to calculate what the prior record score currently is. I'll discuss later about how the new matrix and the new PRS scoring system may lead to possibility of automation, and that these can be generated based upon categorical type of offenses rather than the scoring of the individual prior offenses. And additionally, something I didn't highlight, I guess I will hold off on that. So I know that was really fast, but that was a high level overview of the current matrix, especially as it relates to PRS, and then the impact of PRS and OGS with race on top of it. And so now we're going to move through and take a look at what the academic review panel and our work and what some of those proposals that came out of that group. The primary difference is moving from this point-based system to a categorical system. So as we mentioned, we're moving from 8 categories, or 8 prior record score to 4 categories. The first we have is none. So that's easy to define. It's no prior record. This is our true zero that didn't exist under the current model. Next, we have our low category. And we make a distinction in each of these next set between offenses that are prior criminal history that are single incidents and single victims versus multiple incidents or multiple victims. So we have 2 types for low. We have low A, which is the most serious prior is a misdemeanor 3 or misdemeanor 2. And you could have multiple incidents or multiple victims associated with those, and you'll remain in the low category. Also should note that consistent with the current definition, misdemeanor 3 and misdemeanor 2 juvenile adjudications are not included in the scoring of prior records. So if you had misdemeanor 3 or misdemeanor 2 juvenile adjudications, that's it. You'd be in the 0 prior category. And then we have for low B, we have single incident and single victim misdemeanor 1. So when we move to the medium category, now we have a single incident and single victim for felony 3s, felony 2s, and felony 1s. And we see that in this, we have multiple incidents or multiple victims for misdemeanor 1s or felony 3s. So our low B, if there are multiple incidents or multiple victims of misdemeanor 1, moves over, and essentially F3 will always remain in medium, no matter if it's single or multiple victim or incident. And finally, we have our high category, which is multiple incidents or multiple victims or felony 2 or felony 1s, which is consistent with our repeat felony or repeat violent offender categories from the previous specification. Yeah.
Well, you have that up there. One thing that we've talked about related to the offense gravity score and adjustments to the offense gravity score are some circumstances that somewhat relate to prior record score. One is that there are certain offenses for which the grade is increased because it's a second or subsequent offense. And as we've been talking about, what's in the prior record score, what's in the offense gravity score, it does seem that there could be some consistency if you have a second or subsequent offense, whether the grade increase or not, that the adjustment be done on the offense gravity score column. Think about, someone has something has an OGS 10 assignment, and because it's the second or subsequent, you increase it by 2. And in many cases, the grade is increased as well. So that's something to think about, that if it's the same offending behavior and it's a repeat offense, you deal with it on that axis instead of the prior record score. The other thing that is more probably appropriate for the OGS, but sort of gets to the same issue, is continuing course of conduct. We have some offenses where that's built in as an element of the offense, but it may be worth considering that as just a sentencing factor that we build into the OGS. And to the degree that it's in the OGS, then you would not include it in the prior records.
Can you do, I'm thinking right away of, for example, an endangering welfare of children, I think, where they have I was just thinking for people who don't deal in the criminal law world, that probably sounds super esoteric. So
Sure.
there might be something where there was an endangering the welfare or an indecent assault,
Mhm.
where it was a one-time occurrence versus a course of conduct where it was happening over time, and that jumps it up. I just
Right.
thought of that in terms
No,
of
that's
if
a
people
great
don't know.
example. And on the second or subsequent offense in terms of grading, you have drug offenses, you have DUI,
Mhm.
retail theft, you have a lot of it
Yeah,
like that.
thanks.
Okay, so one of the nice things about this specification is if you took the form on the left, this little mock-up on the right would be essentially how we would classify where your prior record is. So as an example, we have, if you had one prior conviction or adjudication for a misdemeanor one, you would be in the lows. You had two prior convictions or adjudications for a misdemeanor one, you'd now be in the median. And if you had one prior conviction or adjudication for misdemeanor one, or you had multiple victims and had multiple victims, then you would be in the median category. So it's a lot more straightforward system of classifying this. It also allows for, by being based on the grade of the offense, we can also use out of state and look at the maximum sentences that are allowable and then classify out of state a lot easier than we currently do into the prior records.
Yeah, one of the things to keep in mind with the current risk assessment, we've built that into SGS Web. And so what we do when someone starts a case and puts in the OTN, we determine who the offender is. We capture from AOPC all the criminal history they have in their system in CPCMS. And we bring that into our system. And then these magic computers go through and identify the offenses and weigh them for purposes of the risk assessment. We could do the same thing to automate the prior record score in terms of bringing in all offenses, identifying the most serious offenses, and identifying whether there's one or multiple incidences to do this. Now, we can also look at doing that with rap sheets. We can look at other kind of mechanisms. We're going to have to work through a lot of issues with that and have a mechanism that allows for an override if there's missing information or it's incorrect. But it's a way of automating the prior record score way more than, we haven't been able to do that at all. And this would allow us to do that.
Mark, would this information include arrests as well? When you say
No,
data
we would just for this purpose only look at convictions. And that's one of the
and adjudication.
Well, and that's the thing Matt will get to. I think adjudications are, in a separate system. We might not include those, and that might get to your point about reducing the impact of juvenile adjudications. One of the limitations of using rap sheets is the conviction information is not particularly good. So there's greater reliance on AOPC data in terms of convictions that we capture.
Okay, it's a good segue to thinking and talking about juvenile adjudication. So just a quick overview of the current way that they're counted is that juvenile offenses that occurred after the age of 14 are included. They receive the same points currently as adults. There's no cap on the number of points that you can receive for juvenile adjudications. And as I mentioned, we don't count misdemeanor 2 or misdemeanor 3 juvenile adjudications in the prior record score. There is currently a lapsing provision, and that is if the individual remains crime-free between 18 up to the 10 years up to the age of 28, so 18 to 28 crime-free, and 4-point offenses juvenile adjudications do not lapse. That's the current specification of juvenile adjudication. So as I mentioned, we spent a lot of time with the academic review panel looking into this issue, and staff investigated a set of data from 2015 to 2019. So we looked at 5 years of sentences based on the most serious offense in the judicial proceeding. And what you could see is that less than 6% of offenders have a juvenile adjudication, but 10%, 10.5% of Blacks have a prior juvenile adjudication, and 4.3% of whites have a prior juvenile adjudication, and males have a higher probability of having juvenile adjudication than females. So while it's relatively rare in the sense that it's 6%, what we found from the committee or our work with the review panel is the impact of those juvenile adjudications are significant. It can move you across that prior record score where you could see that the recommended duration could increase 4, 5, 6, 9 times. The type of disposition can go from RS to state incarceration. So it has a significant impact on these a small proportion of folks. So in our research, we read a lot about what other states do, and the Robina Institute at the University of Minnesota, echoing a lot of what Judge Tucker just mentioned about culpability in Supreme Court cases and brain development, talk about really that last sentence that a balanced approach might be to include prior juvenile adjudications in the enhancement score, but limit their application. So working with the review panel, we prepared a bunch of different scenarios, taking a look at the impact if we change some of those decision rules. Those were really based on current point-based system, not this categorical approach. So one area we thought we could do some work was related to lapsing provisions. And this also connects to some of the work that Drexel University students did a few years back regarding lapsing. And so there's two types of policies that matter. It's not that important to know specifically what they are, but essentially decay is a set time frame which prior convictions are reflected in the prior record score. So they no longer count at age 21, as an example. Whereas a gap requires that crime-free period, similar to the current juvenile adjudication, the way it works of 18 to 28 of crime-free, then they might disappear. So as relates to juvenile adjudication, we came up with a couple of proposals. First, that the misdemeanor 3 and misdemeanor 2 juvenile adjudications are still not included. For misdemeanor 1 and felony 3s, this is a decay policy that they lapse at age 21. So no matter about crime-free period, but when that individual turns 21, those prior adjudications no longer count towards the prior record score classification. Felony 2 and felony 1s lapse at age 25, except for crimes of violence. And then crimes of violence require that crime-free period between 18 to 28. So this is one way that we've conceptualized reducing the impact of juvenile adjudications on the prior record classifications. So I don't know if anyone wants to comment, or Mark, you have some thoughts to add?
Yeah, I was just going to say these were the preliminary recommendations. One thing you could think about with crimes of violence is the research we've done. We found that lapsing based on the 18 to 28 crime-free period rarely occurs. But if you had a lapsing provision that provided for a 10-year look-back period instead of a fixed term, where a 10-year period of crime-free behavior would allow for a lapsing of a juvenile adjudication. Another option is to think about crimes of violence as something where you reduce the weight of the adjudication instead of eliminating it. So other things to think about, but I think Judge Tucker's point represented what we heard from the academic review panel about real concerns about including juvenile adjudications in the prior record score. But if you're going to try to find ways to really contain them, especially in the out years, maybe initially after 18, there's some role for them, but finding ways to really limit the application.
Just a follow-up question on that. So given that the panel's findings was, they had concerns about including adjudications period, could you just explain more than the rationale for including them, even if it is limited in scope?
Sure. Well, first and foremost, it's in our enabling legislation. So one of the requirements we have is to include juvenile adjudications and adult convictions in the prior record score. So our starting point is that we include them, but then the question is, how much weight do you give them? How do you count them? There's a lot of like flexibility there. So those are some of the issues we're looking at. But the other thing is, through JRI legislation recently, there's a provision that allows the commission to reduce the impact of or the consideration of adjudications and convictions. And so we're looking at that to develop a policy that sort of makes sense, that in cases, especially as the judge was discussing, where there's limited consideration of harm or of risk of reoffense or things like that, that we try to find opportunities to reduce consideration of juvenile adjudications. I think that the toughest thing that we saw was the crimes of violence, because these are kids. Remember, some of these kids are going to be certified or direct filed. There'll be then convictions, and they'll be subject to the regular adult conviction policies. So these are cases that remain in juvenile court, but they're very serious offenses. And, just trying to think of the right balance for that is what we're trying to get at.
Thank you for the explanation. So part of it is that, this body is required to include them. And so we're thinking through how to include them in a way that is mitigating.
Yeah. And trying to take into account sort of the proportionality that for the less serious adjudications, we try to really expedite the removal of those. And for the more serious offenses, we have a more sort of patient approach.
Got it. And then just last thing I'll just say is just sort of more of a comment, just echoing what the judge had said around, I think we're young. We're all, I'm still young. Not to say everyone else isn't. Not to say everyone else isn't. But but we do silly things. Kids, they make mistakes. There's a lot of data that says people age out of recidivism. And I just saw there was a quote on one of the slides. It said, as one of the rationales, that juveniles are held less culpable. And to me, like that, they should be, right? Like you should be held less culpable because they're juveniles, their brains are still developing, they're still forming themselves as human beings. And so I just think that and I know that you all are taking that into consideration, but I do think that it's just something that we should always be thinking about when we consider these guidelines, that these are people that are literally becoming people as they commit these offenses.
Yeah, thank you. And one of the things I mentioned this morning, I think applies here too. We're looking at one aspect of juvenile offending. We're looking at whether adjudications are considered in the prior record score for adult offenders. But the other aspect is, what do we do? What do we recommend for young adult offenders, for 18 to 25-year-olds? And what can we do, whether there's a juvenile adjudication or not? That might be a marker of some type of intervention or treatment or other kind of opportunities or services that we should be thinking about sort of differently than we do about typical adult offenders. So I think it's not just about prior record score, but it's about how do we deal with youthful offenders, brain development, and all the other issues that have been raised. So it's a holistic approach. Judge?
And just a comment, it's beyond the purview of this organization, but so much of this, the plight of a juvenile is dependent upon, and the criminal defendant, is the quality of the advocacy. And you see it in juvenile court, it's like the stepchild of criminal justice, and they don't necessarily get the representation.
I might have to jump through this, but so most states do use juvenile adjudications as calculating prior record score in adult.
They do.
Okay.
Yes.
All right.
Yeah, I think not many of them give the full weight that adult convictions get. They don't see them equivalent, but they do consider them. So
Yeah. So there could be like half points for juvenile, like if it was a 2-point offense, it would be counted as 1 point. In
Okay.
the point system.
Well, and one of the things we always have seen, I think, with the research is, sort of back to our focus on risk, is age of first arrest is I mean, I was always told the primary, one of the top factors for recidivism. So I think it makes some sense in that regard. Not that this is a risk analysis, but to have it. But again, reducing the impact. I think Judge Tucker made some really good points with that. The other thing I think you might want to be concerned about is, from a prosecutorial standpoint, a prosecutor might think, okay, I'm going to allow the kid to stay in juvenile court. I'm not going to transfer him. And if what everybody's telling me, okay, he was young, he's not going to get in trouble again, well, then it never has any impact on them. But if it's not going to count against them as a juvenile adjudication, the prosecutor might be thinking, well, I'll transfer him. That way, when he does get in trouble next time, I can back him up. So there might be some unintended consequences if you eliminate it totally.
Okay, so moving also now to adults. Currently, there is no adult lapsing provisions. Again, building on the work of folks from Drexel University a few years ago, made a number of recommendations to the commission regarding lapsing, working with the academic review panel. We proposed here 2 gap policies for misdemeanor 3, misdemeanor 2, misdemeanor 1, and for felony 3 being crime-free for 10 years and accepting clean slate as proof of that crime-free period. And then felony 2 and felony 1 crime-free for 15 years, so a stricter period. But we heard scenarios in the academic review panel about criminal history when somebody was 20 years old and now they're back at 50, and that counting against them for the stale records. So this is an attempt to accommodate for the stale criminal records. All right, so let me just take a look at what the implications of this new model are relative to some of the analyses that we presented earlier from what the current PRS looks like. So this again is based on 2018 data. We don't have the capability in our data to make all of the lapsing considerations that we've proposed, but this is our best estimate right now of what this distribution would look like. And you see that a little over a third are in our none category, a little over a quarter in our low category, a third in the median, 5% in our high category. And just as a reminder, under the current, we had about half with 0 and 13 with PRS equals 1. So it's retaining that sort of distribution of not overemphasizing the far right side of our scale, even though the bars look higher because there's fewer categories. All right, so I talked about how we might be able to think about or mitigate some of the concerns about racial differences in prior record score. We still see differences here between Blacks having higher prior record scores in medium and high categories relative to whites in none and low. So speaking with Director Bergstrom, one of the things we talked about was maybe leveraging the academic review panel again and speaking to some experts from other states and who worked on the federal guidelines to see if there's any other configurations or things that we might be able to do that can even this out, or if this is just the way it is, unfortunately, and prior record score will unfortunately reflect differences between whites and Blacks. So the last piece, though, I think is, oops, 2 more things, sorry. So good news, at least as if we think about prior record score through the lenses of risk, we see, remember, the current one was not a great reflection of risk. This now has that more traditional stair step. So we're tapping into the idea that these categories do measure differences in risk between the prior record as well as the culpability and retribution component that we've talked about. So there's an improvement there if that is one of the goals of prior record score that just happened to come out of the new configuration. And then, as I highlighted, the academic review panel really talked a lot about reducing the impact of prior record score. So that one example I gave showed it that ratio being 9 times as much. So if you look at the sentencing grid that was shown to you, or we can look here, and we look at, start with OGS 25, the lower limit of the standard range at PRS 0 is 42 months. And then we go to the high it's 60 months. So that the difference is 18 months, but the ratio is 1.4 times. So we really wanted to constrain that ratio to be no more than 2. And this gets to Mark's point that sentence should be primarily based upon current conviction offense and less on the prior records. So this is the group's effort to really tamp that down in a way. Some of that also is because the ranges are narrower and filling the space going up. It's a little bit of a different configuration, but it does reduce the impact here of the prior record score. So that's the last slide we have on this, and happy to entertain.
Why philosophically is that something that the commission wants to do? I mean, I don't know. I don't know that I agree with that. To me, someone that continues to reoffend should be punished more severely than the person that's never been in trouble
Right.
for the same offense.
And we think that that is true, that there should be more punishment. But if, and this goes back to the start of the guidelines, where the statement was that the most important factor for consideration at sentencing is the current conviction offense. We should really focus on an appropriate punishment based on the conviction offense, and that the prior record score and other types of enhancements are just that. They're additive, but there's limits. If you're saying that the most important thing is the current offense, at least the academic review panel said that means that another factor shouldn't more than double what the sentence recommendation is. That was sort of the logic of it. And so that's how they came up with the idea that, the upper level, and we're excluding Revoc from this, but the
Who are
upper
they?
level.
Who are they to decide that?
Well, they're not, but they're saying, look at what you write. They basically looked at our guidelines and said, you say in your guidelines, the most important factor is the current conviction offense. Now, the issue is, what should the current conviction offense be? I mean, I think that gets back to this morning's session, which is, what is the appropriate assignment for that offense? 0 prior record score, that offense. And then the question is, what do you do if it's more than a 0 prior record score? And they were saying, you say that's the most important factor, focus on that. So maybe we have to adjust what the 0 prior record score value is in some cases, but
What says that's the most important factor? The enabling legislation or the?
no, it's been the guidelines since the start. If you look at our guidelines from 1982 through today,
Right.
we always
And
say
I
the
agree
offense
with that.
gravity
I'm just saying,
score.
I know where it's
No,
coming
I agree. And I think we can always, it's your decision, but I think their recommendation was based on looking at our guidelines and what we say the limit should be, even though we didn't apply that.
Mark, can I
Yeah,
make just quick comment?
Sure.
There's a lot of commentary and thoughtful conversations that are going into the issue of what is accountability, right? And so a lot of what I think we're discussing is philosophically, how do you hold someone accountable? Because there's a lot of different ways.
Mhm.
And we have diversion programs, and we have all kinds of options. We have supervised bail and just different things that exist that hold people accountable. We have individuals who would much more would prefer to sit in a prison cell than go through one of our treatment courses.
Sure.
Okay. And so when we think about accountability, one of the things that I'm observing here, and this is more of commentary, and then I'm curious what your thoughts are on it, is along with what Judge Marsico said, the reality is we have to take into consideration repeated conduct. And I know that that's built into this, and I get that. But I'm just stating that from my perspective, as time goes on and someone commits more crimes, and of course, the current crime, of course, that's the main factor when determining a sentence. But at the same time, I think of the risk, I think of the deterrence on the individual as time goes on. And if they know that the prior record score is that doesn't exist anymore.
Mhm.
And I mean, I just feel like we have to make sure that we build into this accountability with regard to prior conduct. I know we have, but I just felt it's important to reemphasize that because there is a duty to public safety.
Mhm.
And that's something that I just wanted to voice. That's all.
No, I think that's important. And I guess the question is, how much additional punishment, accountability, whatever, is linked to repeat offending.
Right.
You know, one of the things, keep in mind, on the offense gravity score for repeat offending, second, subsequent, things like that, there would be an increase in the offense gravity score. So it's not just the prior record score. It's for course of conduct or for repeat offending. We talked about adding steps on the offense gravity score to capture part of what you're talking about. Separately, if there's prior convictions that are unrelated, that's dealt with on the prior record score. So you could move up in both directions based on prior conduct. But the issue is, and it's something the commission hasn't thought about a lot. So this is sort of novel, and it's good that we talk about this, and we'll see if anything what comes about. But the question is, how much more punishment should be linked to previous behavior for which a person was sentenced, served the sentence, and now is in court. And that's what we're trying to understand. And at least the panel thought that doubling is a good measure. And the exception is revoc, because that goes up to the statutory limit as it did before. But so yeah, I don't know, where we'll arrive at this, but I think it's worth questioning whether 9 times the duration of a 0 prior record score makes sense. And if it's not double, is it double for certain things and not for other things? And then, if it's going to be more than double, how much more is appropriate? And like I said, I think we should look at what our base assignments are, because maybe in some cases the base assignments are relatively minor for the conduct, because we figure, we'll stretch it out over prior record score. So maybe there's times we have to look at that as well and say, what's the right recommendation for that first time offense? And then is doubling it for whatever the prior record score adequate? But I'm glad you raised the issue. I don't know what I did, but I think I broke. Okay, there we go.
Mark, let me just follow up on that, because it's an interesting thought. You have a misdemeanor 1, punishable up to 5. I see at some point, it's a topic for another conversation. I see at some point, some astute organization, some defender or whomever will come up with an argument that, okay, he's sentenced to 5 years. Now you've got a prior record score that includes that. And that's going to be used to enhance his sentence, which will expose him to more than the 5 years. That is the maximum that he could receive by statute. I don't know the answer to that, but in effect, I mean, that's what we're doing.
Well, I think you're right. Under the current guidelines, we have a policy that caps the guideline at the statutory limit at the longest minimum sentence, because that's what the guidelines are based on. So you're right. There are times when we bump up against the ceiling because we have really long prior record score recommendations. So yeah, that's how we deal with that. We just cap things. But the question is, is that the basis? I think the argument, aside from, just what's the amount that's due, that's appropriate because of prior offending, not your current offense, but prior offending. So it's that blameworthiness and stuff like that. Like, how much is that worth? And if it's more than double, how much more? But keep in mind also, these are recommendations about the typical sentence for the typical offender. And what you want to do is make sure that the court has the ability to depart above the guidelines, to aggravate if there are other factors, or if this is an egregious situation or whatever else. So it doesn't take that away, but it's, what should be the typical thing. And right now, if we have, cases where it's double and cases where it's 9 times, we don't have a policy. And so the question is what policy makes sense? And we have a recommendation from the academic panel. Maybe it's too low, maybe it's, I don't know, but I think it's a good discussion to have.
And Mark, just real
Yeah.
quick, just to add to
Sure.
what is a very simple issue, clearly, is also you certainly want to provide people an opportunity that, hey, if you remain crime-free,
Yeah.
there's a benefit to that.
Right.
I mean, that's a critical part of what we do, and that decreases crime. And so I
Yeah.
think that obviously we have to come up with a nice
Yeah. Well,
balance.
one thing that this is like ancient history, but I've done some, work in other jurisdictions. And I remember working with folks in Nebraska, and they were doing sentencing reform or policies like that. And one of the things that was like this persistent annoyance in Nebraska was retail theft. These cases going to state prison. And, I forget what it was, they're determined. So like a 1-year sentence got you in state prison. And that was like, people were pounding the table about, longer sentences for retail theft, these chronic retail theft people, what we see around here, and we build in the enhancement to the grade to deal with that to some degree. And one of the takeaways from their sentencing reform effort there was, for some things, there's just a tariff. Like we're just going to decide for that chronic retail thief, every time we get you, you're going to get another year. And it's going to be this like sequential, every time we get you, you get another year. But it's like they said, there's no need to keep jacking it up because what we want to do is punish the person for why they're in court now. And this person's not going to get a message because they're back continuously. But it's not a good use of their resources in Nebraska to put someone in state prison, for that thing or for an extended period of time. They just decided that that's the cap. And it's not inconsistent with what we do with statutory max. We just say, for that kind of offense, here's the cap. And so I don't know that two times is the right number, but I think having a policy or a thought about, what is the right amount, I think that's helpful in terms of just setting a policy about how we construct the prior record score, how much value we think prior convictions have in accountability. So, but one of the things, the takeaways would be, if there's any things we can work on, like to try to dig into this, to look for other information, I think that'll be helpful in maybe figuring out what the best approach would be.
And this is just a preliminary thought that I had while we're sitting here. So I don't know if it would work at all, but I was thinking about consequences of is it causing anybody, if they're like prior record score doesn't really matter anymore, but maybe the opposite of lapsing as a concept is if somebody recommits within a short period of time, that we can have a step up in the OGS as another consideration. So 1 or 2 steps. I mean, there's a lot of ways we can look at it. And I already know as a former prosecutor that if I were a defense attorney and I see something coming down the pike, they're going to play around with conviction dates and so forth. But with all of that in play, it's something where it won't haunt them forever. But if within 18 months of this conviction, you have a second conviction, you bump up an OGS or 2, it would allow us to address it without it being a lifetime burden, but also maybe being that incentive for the person not to recommit.
Yeah, I think that was part, and this came from the strategic planning work group, that they talked about putting prior record score or repeat criminal activity or course of conduct or things like that on the OGS. And I think it was partly that you're dealing with it right there. You're adding a punishment, like an enhancement, because of that behavior right there. But it's not with them for life. You're punishing the behavior there. So some combination of them, I think, has.
Are we taking a break?
I think we are.
You have something?
Judge, the automation is important on many levels throughout the system. I mean, I hope that's something that doesn't get lost in discussion. Because the homicide review team, as you know, we're looking at a lot of values. In 2019, we're studying 43 homicides committed by parolees, and juvenile records were prevalent in many of those records. So, you know, the automation and the availability on that end of the system is important. So whatever we do here, whatever part of the stream, up or down, I hope we don't lose the concept of automating, because there's too many information gaps during these handoffs. And I just want to have people have the right information when they make important decisions.
Sure. Well, first I want to sort of thank the commission publicly. You know, a little while ago, the commission approved bringing on additional staff people to really kick off the next gen SGS web. Christy's here with now almost up to 5 staff in her unit to work on these things. And because of the JRI fundings, we're in a really good position to start to do the architecture for the rebuild. And part of the rebuild, you know, we've talked about this before, these are like in sync. The rebuilding of the guidelines and the rebuilding of SGS Web have to work together. And that improves the quality of the data we have and the ease of application out there. And so yeah, thanks for raising.
So on my desk is a report, I think Pew did it, of our juvenile justice system. And I think you were involved with that, Mark?
No, but I think Professor Rego was.
I'm aware of it.
Yeah.
All right.
Yeah.
Well, so I haven't read it yet,
Yeah.
but if you weren't involved, then I guess this won't help. I didn't know if there was any information in there that would be relevant to the discussion about how to use juvenile records. So it's just something to consider, because I know they did take a pretty deep dive into our juvenile criminal justice system.
They did, and we had the executive director of the Juvenile Court Judges Commission meet with the academic review panel to talk about the report. Hadn't been out yet, but it was close, and so he met with us, and then I did receive a copy of the report, and I think I don't think it's inconsistent with what we've been talking about trying to make sure that that the juvenile justice system looks to reduce placements, reduce formal disposition of cases, look at diversion where possible, all that kind of stuff, and which would have a reduction in the kind of adjudications that would be available to us for prior record score. I think when we talked about juvenile adjudications and the prior record score itself, as I recall, he couldn't speak on behalf of JCJC, but I think that the discussion was in favor of what Judge Tucker and others have talked about trying to be, cautious in the use of juvenile records in criminal court. But one of the things we can do is we can reach out to JCJC and engage with them both about their report, but about any ideas they would have for the guidelines.
Yeah, I think that just might be helpful to be informed on whatever the outcomes were in that report that, as I said, is sitting on my desk for review.
So
but
it's
I think,
a pretty hefty report.
Yeah, and I'm sensitive. I mean, I shared many of Judge Tucker's concerns about relying too heavily upon juvenile adjudications, but I'm also reminded, I think you had a slide that talked about the juvenile adjudication being a pretty heavy risk factor for subsequent criminal activity. And then, Professor Rego's comment about the prevalence of juvenile adjudications in many of these murder cases. So it's certainly a balance that we have to strike in my mind of trying to be mindful that these are younger offenders who are still growing, are still developing. But on the other hand, this is a pretty heavy predictor of future criminal conduct.
Yeah. And one of the things that I mentioned before was, we always have to remember the two categories. There are going to be transfer cases, and they're youthful or juvenile offenders that are being dealt with in the criminal justice system, even while they're, under 18. And those are going to be considered convictions in our book. The question is, if you're retained in the juvenile justice system and you're adjudicated, what about those? And I think you're right. There's a balance that we have to strike. And I'll reach out to JCJC just because they were involved in our group, and we mentioned we'd follow up. I think the report, is this the Senator Baker's, the committee that she chaired? Yeah. Yeah, I'll look at that report again. Thanks.
Looks like it's break time.